actually started working on my drug.
Okay, will Senate please come to order? In lieu of a devotional, we will take a moment of silence. Would you please join me in the pledge?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Are there any announcements? We have Rule 31 referrals this morning. And we have Senate bills S46, S53, S63, and S65 being on the calendar for notice affecting the revenues of the state under Rule 31. They are referred to the Committee on Finance. We now have S36 being on the calendar for notice and carrying an appropriation under Rule 31. It is referred to the Committee on Appropriations. And we now have 5 gubernatorial appointments. What do I? Sent to their respective committees, and it will be printed in the Journal. We now have a Senate resolution for adoption. JRS 18, a resolution relating to weekend adjournment on March 21st, 2025. Please listen to the reading of the resolution.
Resolved by the Senate and House of Representatives that when the two houses adjourn on Friday, March 21, 2025, it be to meet again no later than Tuesday, March 25, 2025.
And the question is, shall we adopt the resolution? Are you ready for the question? All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and we have adopted the resolution. We now have Senate bills for introduction. S 122, an act related to economic and workforce development, introduced by the Committee on Economic Development. Please listen to the first reading of the bill.
S 122, an act relating to economic and workforce development.
Now you've heard the reading of the bill the first time, and pursuant to Rule 48, it's placed on the calendar for notice on the next succeeding day. We now have S 123, an act relating to miscellaneous changes to laws related to motor vehicles, introduced on March 18th, 2025, introduced by the Committee on Transportation. Please listen to the first reading.
S 123, an act relating to miscellaneous changes to laws related to motor vehicles.
Now the bill has been read a first time, and pursuant to Rule 48 is placed on the calendar for notice the next succeeding day. We now have S 124, an act relating to miscellaneous agricultural subjects, introduced on March 8th, 2025, introduced by the Committee on Agriculture. Please listen to the first reading.
S 124, an act relating to miscellaneous agricultural subjects.
Now the bill has been read a first time, and pursuant to Rule 48 is placed on the calendar for notice the next succeeding day. We now have S 125, an act relating to workers' compensation and collective bargaining rights, introduced March 18th, 2025, by the Committee on Economic Development, General Affairs. Please listen to the first reading.
S 125, an act relating to workers' compensation and collective bargaining rights.
Now the bill has been read a first time and pursuant to Rule 48 is placed on the calendar for notice the next succeeding day. We now have S-126, an act relating to health care payment and delivery system reform, introduced by the Committee on Health and Welfare on March 18th, 2025. Please listen to the first reading.
S-126, an act relating to healthcare payment and delivery system reform.
Now the bill's been read the first time and pursuant to Rule 48 is placed on the calendar for notice the next succeeding day. S-127, an act related to housing and housing development. It was introduced by the Committee on Economic Development, Housing, and General Affairs on March 18th, 2025. Listen to the first reading of the bill.
S-127, an act relating to housing and housing development.
And now the bill has been read the first time and pursuant to Rule 48 is placed on the calendar for notice the next succeeding day. We now have House bills for referral. H2, an act related to increasing the minimum age for delinquency proceedings. It was passed the House on March 12th of 2025. Let's see what's going here. And is referred to the committee. Oh, let's listen to the first reading.
H2, an act relating to increasing the minimum age for delinquency proceedings.
Now you've heard the first reading, and it is referred to the Committee on Judiciary. H21, an act relating to service of writs of possession. It passed the House on March 12th, 2025. Please listen to the first reading.
H21, an act relating to service of writs of possession.
Now we've heard the first reading. It's referred to the Committee on Judiciary. We now have H50, an act related to identifying underutilized state buildings and land. It passed the House on January 23, 2025. Please listen to the first reading.
H50, an act relating to identifying underutilized state buildings and land.
Now you've heard the first reading of the bill, and it is referred to the Committee on Institutions. H105, an act related to expanding the Youth Substance Awareness Safety Program. It passed the House on March 11th, 2025. Please listen to the first reading.
H105, an act relating to expanding the Youth Substance Awareness Safety Program.
Now you've heard the first reading of the bill, and it is referred to the Committee on Judiciary. Senator from Chittenden.
Thank you, Mr. President. I move that the rules be suspended and pending entry on the calendar for notice, S-124, an act relating to miscellaneous agriculture subjects, be committed to the Committee on Natural Resources and Energy.
Senator from Chittenden has moved that the rules be suspended and pending entry onto the calendar for notice, S-124, an act related to miscellaneous agricultural subjects, be committed to the Committee on Natural Resources and Energy. Are you ready for the question? If so, all those in favor say aye.
Aye.
All those opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it. And you have committed the bill to the Committee on Natural Resources and Energy. Senator from Chittenden.
I move that the rules be suspended and pending entry on the calendar for notice, the following bills be referred to the Committee on Finance pursuant to Rule 31. S-122, an act relating to economic and workforce development. S-123, an act relating to miscellaneous changes to laws related to motor vehicles. S-127, an act relating to housing and development. And just by way of explanation, this motion and the following motion are just to speed up by one day the movement into the money committees. Thank you, Mr. President.
The senator from Chittenden has moved that the rules be suspended and pending entry on the calendar for notice, the following bills are referred to the Committee on Finance pursuant to Rule 31. S-122, an act related to economic and workforce development. S-123, an act related to miscellaneous changes to law related to motor vehicles. And S-127, an act related to housing and development. Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it. And we have moved those bills to the Committee on Finance. Senator from Chittenden.
Thank you, Mr. President. And finally, I would move that the rules be suspended and pending entry on the calendar for notice, the following bills be referred to the Committee on Appropriations pursuant to Rule 31. S-125, an act relating to workers' compensation and collective bargaining rights, and S-126, an act relating to healthcare payment and delivery system reform.
Senator from Chittenden has moved that the rules be suspended and pending entry on the calendar for notice, the following bills be referred to the Committee on Appropriations pursuant to Rule 31. S-125, an act relating to workers' compensation and collective bargaining rights, and S-126, an act relating to healthcare payments and delivery system reform. Are you ready for the question? If so, all in favor say aye. Aye. All opposed say nay. The ayes have it. And pursuant to Rule 31, the bills have been referred to the Committee on Appropriations. Orders of the day. We have S-45, an act related to protection from nuisance suits for agricultural activities. It was referred to the Committee on Judiciary, which reports it has considered the bill and it recommends that it ought to pass. Please listen to the second reading of the bill.
S-45, an act relating to protection from nuisance suits for agricultural activities.
And the question is, shall the bill be read a third time? I recognize the senator from Franklin, Senator Norris, for the report on the Committee of Judiciary.
Thank you, Mr. President. Good morning. S-45, an act relating to protection from nuisance suits for agricultural activities. When we think about agricultural activities, I know most of us think about those large four-legged black and white individuals, bovine is referred to in and throughout Franklin County and most of the state of Vermont. But we need to keep in mind when we're thinking about agricultural activities in the state of Vermont, it collectively covers a vast area of, people who have goats, people who have pigs, vegetables, maple syrup, beef farms, orchards, Xmas trees, Christmas trees, just to mention a few. The right to farm laws are designated to protect farmers from nuisance suits and other actions where farmers are engaging in typical or commonly accepted agricultural practices. Shields farms from nuisance and trespass lawsuits as long as they follow the regularly accepted practices in agriculture. All 50 states have enacted right to farm laws. Vermont's law is objectively one of the least protective for farmers. This law does not protect farmers from lawsuits if they're negligently operated or violate water quality laws. S-45 would enhance the protection for farmers from suit by expanding the protection to include protection from trespass complaints as well as nuisance, and by amending the criteria for protection. Support for agricultural growth recognizes farming's role in Vermont's economy and aims to prevent premature farmland loss due to legal pressures. Roughly over $4 billion comes in the state of Vermont through agricultural practices. On to the bill. Section 1 amends the chapter in Title 12 that established the right to farm. Section 1 first displays a statutory section that provides the purpose of the right to farm. Specifically, the General Assembly found, among other things, that agricultural production is a major contributor to the state's economy. Agricultural lands constitute unique and irreplaceable resources. Agriculture furthers the economic welfare of the state, and encouragement, development, improvement, and preservation of agriculture will result in a general benefit to the health and welfare of the people of the state. The General Assembly further determined that in order for the agricultural industry to survive in the state, farms will likely change, adopt new technologies, and diversify in products, which for some farms means increasing in
size. But agricultural activities are potentially subject to lawsuits based on the theory of nuisance, and that these suits encourage and could force a premature removal of the farmlands and other farm resources from agricultural use. Therefore, the General Assembly declared the purpose of right to farm law is to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. S45 will further the purpose of the right to farm law and provide improved protection of farms. Also under definitions, the first two were there. The third definition has been added, practices conducted in a manner consistent with proper and accepted customs and standards followed by a similar operators of agricultural activities in the state. This means basically what's generally accepted as proper and accepted as reasonable and prudent individuals. Now, this definition is going to be determined by our courts. It's going to be litigated when suits do come down, and they'll actually come out with a definition that fits this purpose. Section 1 further amends the standards that provide farms with protection from nuisance suits. It strikes the current standard. Currently, a farm is entitled only to a rebuttable presumption from a nuisance suit, but only if the farm can show that it meets multiple criteria, includes conformity with state and federal law. Includes conformity with state and federal law is the key to this. Consistent with good agricultural practices. Establishment prior to surrounding activities and no significant change since commencement of activities. Even if a farmer can prove all the criteria, a plaintiff can overcome the presumption against a nuisance by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious or significant interference with the use and enjoyment of neighboring property. S45 strikes all the current criteria a farm must show to receive the rebuttable presumption. Instead, under S45, no agricultural activity shall be or become a nuisance or trespass when the activity, once again, is conducted in accordance with generally accepted agricultural practices. That's you refer back to the definition on page 1. Plaintiffs generally have the burden of proof in tort claims, but the current right to farm results in the farming having to prove eligibility for protection. S45 puts the burden on the plaintiff. Vermont has a history, both criminally and so on, that when the state brings a charge, it's up to the state, they have the burden of proof to prove beyond a reasonable doubt. In the farming communities, if someone files a lawsuit, it's up to the farms to expend monies and so on and so forth to prove whatever somebody else is asserting is not the truth. So we've simply shifted the burden of responsibility. If you say they're in violation, then you need to show they're in violation and prove that in a court of law. Goes on to say, liberal construction severability. In 5745, S45 also provides that an agricultural activity shall not lose the nuisance or trespass protection under 5743 due to a change of ownership or cessation of operation for not more than 5 years. A change of crops produced, or a change of farming method or conversion of farming practices or agricultural activities to other farming methods, practices, or agricultural activities on a farm. Many of our farms are becoming diversified now because they have to. The price of milk is going down. The price of grain, seeds, and fertilizers is obviously rising. They can't continue on that path. One of the last stipulations is required mediation prior to a suit. To hopefully reduce conflict between farmers and neighbors and to avoid litigation, Section 1 provides that a person shall not bring a court action based on a claim of nuisance or trespass arising from an agricultural activity unless the person and the farmer at least once attempt to resolve through mediation conducting according to the Uniform Mediation Act in 12 VSA Chapter 194. If the parties cannot resolve the relevant issue through mediation, they may to agree to arbitration pursuant and shall share the cost of such arbitration. Prior to a person bringing a court action based on a claim of nuisance or trespass from an agricultural activity, they shall provide the court with a sworn statement of an attempt to resolve the issue or dispute through mediation. Section 2, the effective date is July 1, 2025. Your Senate Judiciary Committee heard from the following witnesses: an attorney from Green Mountain Law, general counsel from the Agency of Agricultural, Food and Markets, a partner at Course Farm Dairy LLC, the sponsoring senator from Orleans District, policy and water program director from the Vermont Natural Resource Council, Manning Dairy LLC, Vermont Association for Justice, the Crasson Group, our Chief Deputy Counsel, Office of Legislative Counsel, Pool and Grain, Monahang Safar PLLC, Manager of Farm and Food Conservation Law Foundation, Pleasant Valley Farm, and an owner of Vorstebelt Farm. The bill passed Senate Judiciary on a 4-to-1 vote, and we ask for this body's support. Thank you.
The question is, shall the bill be read a third time? Are you ready for the question? Senator from Essex.
Mr. President, I want to thank the Judiciary Committee for allowing Senate Agriculture to take a peek at this bill. We reviewed it and did a straw poll vote and voted in favor of 5-0-0. Thank you, Mr. President.
Are you ready for the question?
Roll call.
A roll call has been requested. Are you ready for the question? The secretary shall commence the roll.
Senator Baru.
Yes.
Senator Beck.
Yes.
Senator Conger.
Yes.
Senator Brennan.
Yes.
Senator Brock.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
No.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Douglas.
Yes.
Senator Bueller.
No.
Senator Hardy.
Yes.
Senator Harrison.
Yes.
Senator Hart.
Yes.
Senator Hashi.
Yes.
Senator Heffernan.
Yay.
Senator Ingalls.
Yes.
Senator Lyons.
Yes.
Senator Major.
Yes.
Senator Mato.
Yes.
Senator Norris.
Yes.
Senator Frischley.
Yes.
Senator Plunkett.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Bohosky.
No.
Senator Watson.
No.
Senator Weeks.
Yes.
Senator Westman.
Yes.
Senator White.
No.
Senator Williams.
Yes.
The ayes 25 and the nays 5. The ayes have it. And you have ordered third reading of S 45. We now have Senate Resolution JRS 15, joint resolution supporting Vermont's transgender and non-binary community and declaring Vermont's commitment to fighting discrimination and treating all citizens with respect and dignity. Are there any amendments prior to third reading? Please listen to the third reading.
JRS 15, joint resolution supporting Vermont's transgender and non-binary community and declaring Vermont's commitment to fighting discrimination and treating all citizens with respect and dignity.
The question is, shall the resolution be adopted? Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have adopted JRS 15. Where are we at? 15. We're passing over S 59. Now we have S 66. An act related to motor vehicle noise, exhaust modifications, and engine compression brakes. Let's see, where am I at? It was introduced by the committee, no, it was in, where am I here? It was referred to the Committee on Transportation, which reports it has considered the bill and recommends that the bill be amended as it appears in today's calendar, and that when so amended, the bill ought to pass. Listen to the second reading of the bill.
S 66, an act relating to motor vehicle noise, exhaust modifications, and engine compression brakes.
We recognize the senator from Windsor for the report on the committee.
Thank you, Mr. President. Today, I stand before you to introduce a vital piece of legislation, S66. I see that you were just handed out a copy of the bill, but you may also find the amended version in your Senate calendar on page 156. Senate Bill S66 is a transportation noise bill designed to protect the health, quality of life, and the environment in our beloved Vermont communities. Noise pollution is an often overlooked aspect of public health that can have profound impacts on the well-being of our residents. Studies have consistently shown that excessive noise can lead to stress, sleep disturbances, and even cardiovascular health issues. In addition, we heard that excessive noise on our roadways can lead to more dangerous interactions between pedestrians, bikers, and every other driver. Currently, Vermont has some of the weakest vehicle muffler laws in the country, and this has given rise to a growing number of inadequately muffled vehicles on our roads. In particular, we identified illegally modified motorcycles, heavy trucks lacking engine compression brake mufflers, and intentionally loud cars and light trucks. These vehicles disrupt the peace of our neighborhoods, harm our health, and degrade our environment. And it's time that we adopt measures that can help reduce the noise and improve the lives of those who are impacted in our cities, towns, and villages. Here are a few of the key measures that are addressed. First, we implement a tightened state inspection process so that motor vehicle exhaust standards that they will prohibit inadequately muffled vehicles and those that have been modified in such ways to make them louder. This is not a bill to address poorly maintained mufflers or those who are unable to afford improvements to their mufflers, but rather those who modify those mufflers intentionally to make them louder. I probably don't need to describe to you the experience of having a young driver who has gutted their muffler drive by your home multiple times in an evening. You've probably familiarized yourself with that on your own. We're not talking about low-income Vermonters who have poor quality mufflers due to not being able to maintain them. That's not who this bill is addressing. It's intentionally making them louder. No longer will we allow these excessively loud vehicles to roam our roads unchecked by inspection. Second, we address noise pollution caused by heavy trucks by requiring them to muffle their air compression engine brakes. These brakes, while necessary for safety, can be extraordinarily loud and disruptive, especially in residential areas. I'm not going to make the noise for you, but you know what it sounds like. Third, we ensure that motorcycles meet federal EPA noise standards by requiring them to have mufflers that are labeled with a commonly required EPA sticker. The EPA sticker would provide evidence that the noise produced by the muffler is limited to the maximum of 80 decibels. This will reduce the number of illegally modified motorcycles that contribute to noise pollution. Fourth, the bill continues to authorize our communities to ban unmuffled air compression brakes in sensitive areas. Many of our downtowns and villages and those centers already have ordinances that say you cannot use a Jake brake, aka an unmuffled brake, in our downtowns, and this bill does not seek to override those already existing requirements. This will allow local governments to protect their residents from the harmful effects of noise pollution, particularly in areas close to schools, hospitals, and parks. Finally, we initiate further planning by requiring a study to recommend noise limits on motor vehicles and the tools for effectively and efficiently enforcing those limits. This will enable us to establish a framework for controlling noise levels in our state, ensuring that we maintain the tranquility that makes Vermont such a treasured place to live. The Senate Transportation Committee heard testimony and received comments from approximately 30 individuals, including a noise expert, a pediatric physician, attorneys, a policy consultant, the Department of Motor Vehicles, law enforcement professionals, business owners, and various nonprofit organizations, and a great number of people who are impacted firsthand. The majority of the opinions we heard were in support of the bill with trimming done. Those in support asked the committee to pass a bill that would provide some relief from the loud motor vehicle noise that was impacting their daily lives. We even heard that excessive noise had driven and could drive more Vermonters out of their homes, meaning they no longer felt that the home they lived in was comfortable for them to be in because of excessive noise. Picture being out on your porch and you don't even want to be out there to barbecue on a beautiful summer day because the road noise won't even let you have a conversation with your spouse in your own backyard. Many of those individuals said they tried to get law enforcement help, but were essentially ignored. And in some cases, they were told that the lack of enforcement was due to the state not having clear enough laws on the books for them to enforce the issue. This bill seeks to resolve that unclarity with clearer, stronger laws that can be effectively enforced. This bill is a compromise bill. There were concerns raised about the impacts of it potentially on commercial trucks. In the original bill, if you heard from constituents, there was a provision to not allow fleet inspection or inspection done by the individuals who own the vehicle. So you can't inspect your own vehicle. We took that out because we did hear from relevant stakeholders that that's a very valuable part of their commercial fleet work. It would be more expensive essentially for them to go get another inspection site rather than continuing self-inspection. So that was removed from the bill. This bill also curtails the loudest and most obvious sources of loud vehicle noise. It does not seek to implement any measures that would unnecessarily impact the average driver in any way that could cause undue hardship. It provides exemptions for motor vehicles participating in special events. So if you have a contest, a race, all of that, an exhibition, that is exempt. And for the use, and we do actually put in a very specific provision where if you need to use your engine compression brakes and you do not have a muffler and you're in an unsafe emergency situation, yes, you can still use your unmuffled Jake brake in that situation. This bill is a reasonable measure that would address the unreasonable noise being produced by certain motor vehicles and their owners who travel on our state roads. In conclusion, we all live in an acoustic environment, and Senate Bill S66 is an opportunity for us to improve that acoustic environment by addressing the harms caused by excessive noise, which will improve our health, quality of life, and the natural environment in our state. This bill is a product of compromise and discussion in Senate Transportation, and I'm grateful for our chair's leadership because we were able to slim down the bill considerably from its introduced form. Obviously, I introduced the bill. And while we slimmed it down, I think we found the real important parts of what we heard from concerned constituents, and that led us to having a 5-0-0 vote. And that includes a positive vote from one member of our committee who happens to have a 66 GTO Fontaine Blue. I'll let you figure out which of our 5 votes owns that vehicle. Let's come together in support of this bill and take a proactive step towards a quieter and healthier Vermont. Thank you.
Senator White, I really wish you would have provided us with your interpretation of the sound of a Jake brake. That would have been beneficial for everyone. The question is, shall the bill be amended as recommended by the Committee on Transportation? Are you ready for the question? Senator from Addison.
Mr. President, can I interrogate
The presenter is interrogated.
one question is the sound equipment to measure. Does the state have that, or do we have to buy it?
I think.
And is there, and what is the cost?
So we don't require in the bill at this point any, we slimmed down the section that would have had enforcement that would have required decibel meters, for example, which I think is what you're referring to. There are also noise cameras. An inspection station is who would actually be enforcing this, so it wouldn't be the state itself.
So
So
on,
we
on
don't
page,
own.
sorry, Mr. President, but on page 4, section 5, it's from paragraph 5 to 8, it does specify that we are, that the officer may measure the vehicle with the level of the sound meter noise camera. Where is that money coming from to do this?
I appreciate the question. That is, I think the paper you're looking at is the as introduced version. So that is not in the bill that we're looking at today. If you would like to find that section as it is, you would go to Senate calendar page 156. I do not believe that is in the bill as it stands. But I appreciate the question. That was an example of compromise.
And I appreciate that, and thank you. So I updated Bill. My learning on the floor. Thank you, Mr. President.
Are you ready for the question? Senator from Washington.
Thank you, Mr. President. May I interrogate the proposer?
The proposer is interrogated.
I'm just trying to make sure, when you talked about traffic noise that kept people from being able to have a discussion on Saturday, Sunday afternoon in their backyard. We have locally, and I know there are other ones, a speedway. And I know that when they are running, it's very difficult to have a discussion in some backyards. And with the hills and mountains, it's actually louder 3 miles away than it is there. Are we going to shut down the speedways? And are half my constituents going to be furious with me?
I thank the member for the question. We specifically exempt certain, I'm trying to find the specific subdivision, but we specifically in the bill exempt races, exhibitions. It's section 3 of the bill. We specifically exempt them. So I don't believe your constituents will be furious with you because they are exempt if they're participating in a event, which I believe is the speedway. They're a designated event.
It has a regular season, so it is not any, to me, an event is something that happens once. They happen, I think it's every Thursday and Sunday. I just want to make sure that that is covered under the event.
Yes, my understanding is that would be covered under the bill. And I'm seeing a very enthusiastic nod from our legislative council because I think you're right. Vermonters want to be able to participate in sports. This is a culture. We have a beautiful car culture in our state. And I don't think anyone wants to see that economic engine go away. So I appreciate that question.
Thank you. Thank you, Mr. President.
Senator from Chittenden.
Thank you, Mr. President. May I inquire of the presenter of the amendment?
The presenter is inquired of.
Wonderful. As I read through this, it appears that a violation would simply mean that someone would not pass inspection. Is there any law enforcement mechanism in this bill? Could someone be pulled over because their exhaust was loud?
You can be pulled over now as a secondary offense if you have exhaust improperly, if your exhaust is, I'm not exactly sure what the exact wording is, but if you have an exhaust system that does not currently meet our standards, you could as a secondary offense. Now, this bill does not add to that or change that.
But that is a secondary offense, so you couldn't be pulled over for it. You could simply be charged with it if you were pulled over for something else that is a primary offense?
That's my understanding. Nothing in this bill makes any primary or secondary offenses.
Great. I thank the presenter.
Senator from Rutland.
Thank you, Mr. President. Just as a point of clarification, if folks want to look on page 156, at the bottom of the page in section 1, subdivision 3, I think it would answer the senator from Washington's question regarding the exemption. It does say when a motor vehicle or motorcycle is operated in a race, contest, or demonstration of speed. Thank you.
Are you ready for the question? Senator from Windsor.
I'd like to thank Senate Transportation. This has been an issue for many of us who live in communities that are right on a major state highway or a major road of some variety. This has long been an issue for the town I live in, and I had introduced a bill when I was in the House on this and got nowhere. So I'm really delighted that this is going forward, and thank you, Senate Transportation.
Are you ready for the question? Senator from Chittenden.
Thank you, Mr. President. I, too, would like to congratulate the committee and its chair. A 5-0 vote on a bill like this is unusual, and it came about because, as we heard, there was significant compromise at every level. You've seen through the interrogation process that there is a ready answer to all of these questions. They're already in the bill or were taken out of the bill. So that is exactly the kind of work we've been trying to do, tripartisan work that actually improves the lives of ordinary Vermonters. So thank you to the committee.
Are you ready for the question? Senator from Franklin.
Thank you, Mr. President. May I interrogate the presenter of the bill, please?
The presenter is interrogated.
Mr. President, I see we're on page 4, C1. In my personal opinion, that may cause some concern or whatever when it comes to law enforcement. My fellow senator from Addison County already brought that to our attention. But not being familiar with decimal meters and so on and so forth, I see on page 3, lines 14 through 17, where it says 72 decibels on a scale at 50 feet versus 80 decibels at a scale of 50 feet. I'm not quite sure what that level is. Is that the noise of one rooster crowing in a barnyard or 10 roosters crowing in a barnyard? I'm not sure exactly what we're looking at here. If I could have some explanation on that, please.
I don't know the roosters to noise ratio. We did not familiarize ourselves with that standard. And again, I so appreciate that question. That was under the original bill. If you refer to your Senate calendar, you will see that is no longer a part of the bill.
Thank you, Mr. President. On a more serious note, a lot of times in our county, my county that I come from, there's certain motorcycles that enjoy traveling on our highways and so on and so forth. And as everybody knows, there's a lot of difference between the noise that these motorcycles make when they travel in a group of 10 to 15 or even more. Does this bill covers that, and do they have to conform with the noise levels on this decibel?
There is no decibel requirements in the bill as passed out of our committee. We do ask the Secretary of Transportation to report back to us on what an appropriate standard would be. In speaking to my own personal constituents, when we discussed the bill, if you're going to a designated motorcycle, if you're going to Laconia and you are designated and you're a group of folks, you could be considered a part of that exemption. If you're going to an event like Motorcycle Week and you're moving together and you have proper documentation, I think that you would be exempted under the current bill. However, we don't have any of those requirements as the original bill.
I thank the presenter of the bill, and I thank you, Mr. President.
Senator from Chittenden.
Thank you. Just quickly for senators, just a reminder that when we take up a bill, you're going to get the original, and there's the amended version in the calendar. You can tell when you look at the version in the calendar whether it's a strike-all. If it is a strike-all, it's not that you would ignore the original bill. It's given to you for a reason, which is that the first thing we're going to vote on is whether or not to amend the bill. So in this case, or in any case, the original bill is up for your preference, as is the amended version of the committee. So there's a reason to pass it out, but I think in general, just looking at what's in the calendar is the easiest way to familiarize yourself. Thank you, Mr. President.
Are you ready for the question? Senator from Chittenden.
Thank you, Mr. President. May I make
The
a friendly
presenter of
inquiry?
the amendment is interrogated.
Thank you. Perhaps I'm channeling the former senator from Caledonia and my own husband, who is avid about his motorcycle riding. There is a distinction between the use of the word motorcycle and motor vehicle in the earlier sections of the bill, such as Section 1. But as I look at Section 4 on motor vehicle noise levels, I only see reference to motor vehicles. And so I'm simply inquiring of the reporter of the bill if there is going to be further consideration of motorcycle noise requested in that report, or what exactly does it mean in Section 1, subsection 2 to be labeled in compliance with 40 CFR 205-158? Because we talked so much about modifications to motor vehicles and not necessarily decibel levels or sound levels for motorcycles.
I think that's a multi-part question, so I'll start with the latter half. Yes. The first section you referred to around 40 CFR 205-158 and equipment of a motorcycle having a stamp. You might be familiar with this from actually last session. Senate Transportation worked on it. If you have a muffler and you have a motorcycle after 1985, you essentially have to have this stamp on it when it's produced. So if you purchase a motorcycle or even you know, the trinkets that come with it from an authorized dealer, they will already come with that stamp. So if a motorcycle driver is adding a performance exhaust system, that's not what we're talking about. We're talking about when someone changes a muffler or creates a muffler or purchases a muffler that is not by, I would say, a regulated entity. Those stamps would not exist on that muffler because it's required by the EPA now. So what we're saying in that first section is that you need to have that stamp, and if your vehicle is younger than 1985, because prior to 1985, that was not in the same, we didn't have that regulatory framework. So pre-1985 motorcycles are exempt. Post, you're gonna need the stamp. And that was also looking at, do you want someone at the side of the road, or do you want an inspector to know? No, you want them to have something that's a tangible metric. Does it have a stamp or not? So that's what we're regulating motorcycles under. You raise an interesting point with the report in section 4, because I don't see motorcycles listed within the report, but my assumption is that when we require the noise level report from DMV and the Agency of Transportation, that they will cover motorcycles based on it being considered road noise. But we do feel that the stamp will be an effective tool now, and what we heard from motorcycle enthusiasts was something that they should have on their motorcycles already. It's not something they're going to have to get. It should come when you purchase the motorcycle or purchase the part at this point.
I thank the Senator.
Are you ready for the question? If so, the question is, shall the bill be amended as recommended by the Committee on Transportation? All those in favor, say aye. Aye. All those opposed, nay. The ayes have it. And we have, where am I? The ayes have it, and you have amended the bill as recommended by the Committee on Transportation. The question is now, shall the bill be read a third time? Are you ready for the question? If so, all those in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S66. No problem. We now have S87, an act related to extradition proceedings. Introduced on March 14th, 2025, it was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as it appears in today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S87, an act relating to extradition procedures.
Recognize the senator from Windham, Senator Hashim, for the report of the committee.
Mr. President, this bill is located on page 159 of today's calendar. Excuse me. S87 is a component of the Public Safety Omnibus Bill, which makes some technical changes to the constitutionally required process of extradition. It brings the procedure into the 21st century while also alleviating some duplicative administrative work. So just for some context, extradition is the process of surrendering the custody of a fugitive from one state or country to another state or country. The process is required under Article 4, Section 2, Clause 1, and Clause 2 of the U.S. Constitution, which enshrines the concepts of comity and extradition. Clause 1, which is known as the Privileges and Immunities Clause, and which enshrines comity, was in part drafted for the purpose of creating more unity between the states, and essentially requires that states respect each other's laws. So that's, for example, that's part of the reason why you can, if you have a Vermont driver's license, you can legally drive in Massachusetts with that same license, but if your Vermont license gets suspended and you get pulled over in Massachusetts, you can also get a ticket for driving with a suspended license, even though you have a Vermont license. Clause 2 is specific to extradition and applies to serious offenses like treason and felonies. So for example, if someone from, let's say, Wisconsin has a warrant because they shoplifted and they come to Vermont where they get pulled over, the officer may see that they have a warrant in Wisconsin, but it's not going to be extraditable. However, if they have a warrant for homicide, they'll have an extraditable warrant. And that would make Vermont the holding state and Wisconsin the demanding state. The changes that this bill is attempting to remedy involve the timelines and waivers for extradition. Under current law, when a fugitive is arrested in Vermont, the state's attorney will have 30 days to process the paperwork and get a warrant from the governor of the demanding state. A majority of the time, the state's attorney will request an extension of 60 days, which is currently allowable under 13 VSA 4957. So instead of requiring that they go through the process each time of getting an extension, the first change in Section 1 allows the extradition process to occur within 90 days rather than 30 days. The 90-day timeline is also established as a guideline in the Uniform Criminal Extradition Act, which Vermont adopted in 1933. The second change in Section 2 allows for an extension of 30 days. The current statute allows for a 60-day extension. The administration's original proposal was to allow for 120 days while awaiting extradition and to keep the 60-day extension. This could result in someone being detained in the holding state for a total of 180 days. And considering that we're talking about a person's liberty interests, we brought that number down from 120 to 90 while allowing a 30-day extension if necessary. Section 3 addresses written waivers of extradition proceedings. Currently, the only waiver of extradition proceeding recognized in Vermont is one in which the accused signs the waiver in front of a judge after being advised of their rights. The amendment in this section recognizes a waiver of extradition previously signed by the accused as a term of the person's current probation, parole, bail, or other release in the demanding state, provided that Vermont receive an authenticated copy of the prior waiver of extradition signed by the person and photographs or fingerprints or other evidence properly identifying the person as the person who signed the waiver. Additionally, all criminal charges in Vermont need to be disposed of through trial and sentencing unless the state's attorney determines that extradition is in the interest of justice. So regarding that last sentence, it's another hypothetical. Going back to that person from Wisconsin in the earlier example, who's wanted for homicide in their home state, but commits a petty larceny in Vermont, the state's attorney will likely say that it's in the interest of justice to extradite the person back to Wisconsin for the homicide offense rather than holding the person here to address the larceny offense. On the other hand, if that person from Wisconsin commits homicide in Vermont and is also wanted for homicide in Wisconsin, the state's attorney will likely say that the defendant must resolve their Vermont homicide case before being extradited back to Wisconsin. Section 4 addresses hearings, commitments, and discharge. This section amends the hearing process for the purpose of determining the lawfulness of the arrest by reflecting the extended period of holding allowed by Section 1, which is 90 days. Additionally, if the court is considering releasing the accused on bail pending issuance of the warrant from the demanding state, the court shall consider the evidence that the accused has fled justice to Vermont from another state when determining the risk of flight from prosecution. Section 5 addresses the effective date. It will take effect on passage and shall apply prospectively and not affect extraditions in process at the time of enactment. We heard from General Counsel from the administration, the Department of Public Safety, the Defender General's Office, the Attorney General's Office, and the State's Attorney's and Sheriff's Office. The vote in committee was 5-0-0, and I ask for the Senate support.
The question is, shall the bill be amended as recommended by the Committee on Judiciary? Are you ready for the question? If so, all in favor say aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Committee on Judiciary. Now the question is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have ordered third reading of S. 87. That completes the orders of the day. Senator from Chittenden.
Thank you, Mr. President. A reminder that this week we're changing our floor times to allow afternoon money committees additional time to move things out by the crossover deadline. So pending announcements, I would move that the Senate stand in adjournment until 11 a.m. Wednesday, March 19th.
Are there any announcements? Senator from Washington.
Thank you, Mr. President. Senate and Finance will meet. Right now, we're scheduled for 1:30, but we're trying to get witnesses in at 1 o'clock. So please check in at 1 o'clock.
Are there any announcements? Senator from Wyndham.
Senate Judiciary will meet immediately after the fall of the gavel.
Senator from Wyndham.
Thank you, Mr. President. Senate institutions will meet at 1:30 today.
Senator from Windsor.
Senate Economic Development, Housing, and General Affairs will meet immediately after the fall of the gavel at 10:30. Thanks.
Senator from Chittenden.
Health and Welfare will meet 5 minutes after the fall of the gavel.
Senator from Washington.
Natural Resources and Energy will meet at 10:30.
Senator from Rutland.
Government Operations will meet at 1:30.
Senator from Essex.
Thank you, Mr. President. Senate Agriculture will meet at 10:45.
Are there any other announcements? Senator from Chittenden.
Thank you, Mr. President. I would like to let senators know that we have some visitors in the building today. There are members of our community who would be evicted into unsheltered homelessness should we not find a solution to the emergency housing issue that are here to visit with us today. Again, we are asking our most vulnerable Vermonters to come here and beg for their basic needs. Nobody disagrees that the motel program is not the best housing option, but I would hope that senators would find time to talk with some of the people in the building today about the immediate impact it would have on them if we ended that program. Thank you.
Are there any more announcements? Seeing none, the senator from Chittenden has moved that we adjourn until 11 a.m. on Wednesday, March 19th. Are you ready for the question? If so, all in favor say aye. Aye. All opposed say nay. The ayes have it, and we have adjourned until 11 a.m. Wednesday, March 29th.